Character evidence. So, character evidence is evidence regarding someone's general personality, traits, or propensities of a praiseworthy or blameworthy nature. It is evidence of a person's moral standing in a community. It not only means disposition, which is the personal makeup, temperament, or character, but also the person's general reputation in the community. So, character includes both reputation and disposition of a person. So, what is disposition? Disposition is the inherent qualities of a person. These are qualities that a person acquires through their upbringing, education, or material conditions in life. The argument is that you are going to be predisposed to an act in a particular way because of the way you are brought up or because of how you live or your education. The way to tell a person's disposition is through observing the person. How are they likely to behave in a particular circumstance? So that is disposition. Reputation is more specific. It refers to the general estimation with which a person is held. It is the net effect of the interaction that you have with other people. So that is reputation. So character evidence includes both disposition and your reputation. So when is character evidence admissible? So we're going to break down this into character evidence under civil cases and character evidence under criminal cases. So we'll begin with character evidence in civil cases. In civil cases, the general policy is to reject evidence of the character of the parties. So the general principle in civil cases is that evidence of the character of the parties will be rejected. Evidence of character in civil cases cannot be led to establish the commission of a wrong by bringing their character before the court. The argument is that the business of the court is to try the case and hence should not be interrogating or inquiring into a person's entire life. The general principle is that evidence of character is not admissible under civil cases. However, there are 3 instances where it can be admitted. Number 1 is when such evidence is an issue or directly relevant to the issue. So if the evidence is an issue and if it is directly relevant to the issue in question, then the character evidence will be admissible under the civil cases. And number 2, when the character is such as to affect the quantum of damage. So if the character is going to affect the way in which the court is going to estimate the quantum of damage, then it is going to be admissible. The character number 3 is that the character of a witness is relevant to establish his credibility. In that, if the character of that evidence is going to establish his credibility as a witness and in the civil case, then it is going to be admissible. But generally, evidence of character is not admissible in civil cases. So our next category is character evidence in criminal cases. So this one has a wide scope. So in criminal cases, a distinction is made between good character and bad character. So in criminal cases, the fact that the accused is of good character is admissible. And the fact that the accused person has been convicted or has committed or has been charged with any offense other than that which he is being charged or is of bad character is inadmissible. So in criminal cases, we can see that the fact that the accused is of good character is admissible. And generally in criminal cases, bad character is not admissible. So the good character of the accused is going to be admissible under the criminal cases. So The accused is allowed to adduce evidence of his good character under the criminal cases, and this may be done in the examination in chief by the accused himself or other defense witnesses, and also in the cross-examination of a witness called for the prosecution. So where the prosecution's witness is called and he's being cross-examined, the good character of the accused can be brought out. So we're saying here that an accused person who gives evidence of his own good character, either in chief or by cross-examination of prosecution witnesses, opens himself to the risk of the prosecution being allowed to give evidence of his bad character. Remember, we said that in criminal cases, the bad character of the accused is not admissible. But, however, here we're being told that if the accused person, either in cross-examination or examination in chief, opens himself and brings out his evidence of his own good character, then there's a risk, and the prosecution will then be allowed to give evidence of his bad character. So we said that in criminal cases, only good character is allowed, not bad character. However, there are exceptions to this general rule. The first one is that, so this is where now, the exceptions is where now the bad character will be allowed and will be admissible in court. So number one is that the proof he has committed or been convicted of such other offenses is admissible to show that he is guilty of the offense with which he is charged. So where it comprises of similar fact evidence, then the bad character will be admissible. So here there's an example of a case. It's a case law, R versus Coker. Coker was charged with breaking and entering with intent to steal. In his defense, he alleged that he had entered for the sake of warmth and sleep. Evidence was adduced of a similar charge in the past, where he had also pleaded the same and was acquitted of that similar charge. He was convicted based on the conviction. So Coker decided to appeal the conviction based that it was inadmissible evidence of previous offense. The court held that the conviction did not result in a conviction and was therefore not under the exception. So here we're being told that if the person was convicted of a similar offense, then it is going to be his bad character can be admissible. But if he was not convicted, like Coker, who was not convicted of the offense and was acquitted, this is not going to apply to him because he was not convicted. So the second exception to the general rule that bad character evidence is inadmissible is evidence of bad character is admissible where the accused was personally or by his advocate asked questions of a witness for the prosecution with a view of establishing his own good character. Then he will be questioned on bad character. So if the accused or his advocate asks the prosecution witness questions with a view of establishing his own good character, then he will be questioned on his bad character. So if an accused is telling the court that he is of good character, the prosecution can show the court that he is not such a good person after all. The accused lays himself bare for the prosecution to show the court that he is not as good as he alleges. That is exception number 2 to the general rule. Exception number 3 is where nature or conduct of the defense is such as to involve imputations on the character of the complainant or of a witness for the prosecution. So if an accused person raises an issue in his defense that casts aspersions on the complainant or witnesses, he can be questioned on his good character. So if during cross-examination of the prosecution witnesses, or when the complainant is being examined or cross-examined, and the accused person raises an issue in his defense that casts aspersions on the complainant or the witnesses, he can be questioned. Then the prosecution is allowed to question him on his good character. So I have an example of a case where the appellants were charged with robbery with violence. So during cross-examination, the first appellant suggested that the police sergeant who had given evidence against him was committing perjury. Thereafter, the court allowed the prosecution to put questions on the first appellant touching on his past convictions. The appellant was convicted, so they appealed, challenging admissibility of the evidence of past convictions. The court held that if the defense involves a proposition that the jury ought not to believe the prosecution or one of the witnesses of the prosecution, then the jury also needs to know what kind of character the prisoner has. If you are saying that the prosecution witness ought not to be believed, then the court needs to know if you are to be believed. So that is the third exception. And the fourth one is accused person can be questioned on his previous antecedent if he gives evidence against any other person charged with an offense. So basically this means that if the accused gives evidence against a co-accused with whom they are charged with, then evidence of his bad character will be admissible. However, we must note that it is explicitly provided in our jurisdiction that the prosecution has no right to comment on the silence of an accused. An accused person has the right to remain silent. The question has arisen that since the prohibition of commenting on silence is on the prosecution, can the judge comment? So in R versus Bathurst, this case considered the question, and it stated that the judge could only properly tell the jury that the accused has a right not to testify, and number two, they must not assume that the accused is guilty because he did not testify, even though they have been deprived of the chance to test the story told in the cross-examination. So if the accused person chooses not to testify, it should not be made a subject by the prosecution. But if he chooses to testify, then he is treated like an ordinary witness and he can be cross-examined. Thank you. That's it for character evidence. Bye.